5 seconds to go. Start. This appeal has been preferred by the son of Shri Jai Prakash, a deceased constable in Haryana Police, seeking appointment on compassionate grounds as his father and another constable died while on duty on 22nd November 1997. The appellant then was 7 years of age, and the policy which was in force was dated 8th May 1995, which provided for ex gratia appointment confined to class 3rd and 4th posts. The widow of Balwan Singh, the other police constable who died along with the father of the appellant, was granted compassionate appointment as a constable upon her application. The mother of the appellant, being illiterate, could not seek an appointment for herself and therefore applied for compassionate appointment for her son, the appellant herein. A letter from the Director General of Police Haryana, hereinafter referred to as DGP, dated 15th April 1998, was received by the Superintendent of Police on 20th April 1998, directing the name of the appellant Tinku, son of deceased Constable Jai Prakash, to be entered in the Minors Register number 47. This indicated the intention of the authorities of reserving one post for grant of employment to the appellant at a later stage, being minor child of deceased employee as per the applicable policy. Since the appellant was a minor, his claim was kept pending. A further communication from the office of the Superintendent of Police Rohtak, dated 30th December 2003, was received by the mother of the appellant that, on attainment of the age of majority, the appellant should approach the office of the welfare inspector to get the case prepared. It is on this basis that the appellant approached the DGP by way of representation dated 30th October 2008, putting forth his claim for appointment under the ex gratia scheme, specifying therein that he had attained the age of majority on 10th October 2008. His mother also submitted a representation to the DGP making reference to the early communications as mentioned above for the grant of appointment on compassionate grounds as per the policy. The claim of the appellant was considered and communication was received from the DGP dated 28th April 2009, addressed to the Superintendent of Police Rohtak with a copy thereof to the mother of the appellant, intimating rejection of the claim for appointment on compassionate grounds. The reason assigned was that from the date of death of the appellant's father till he having become major 11 years had passed, rendering the claim time barred when taken from the date of death of the father of the appellant. For this, reliance was placed on the government instructions dated 22nd March 1999, where a minor dependent of a deceased government employee gets the benefit provided he/she attains age of majority within a period of 3 years from the date of death of the government employee. It was further intimated that, as per the Haryana Compassionate Assistance to the Dependents of Deceased Government Employees Rules 2006, hereinafter referred to as the 2006 rules, which were then in force, whereunder the claim was considered, did not contain provision for providing a job under the ex gratia scheme. Faced with this situation, the appellant had preferred a writ petition before the High Court in the year 2009 with the plea of promissory estoppel in the light of communications received referred to above. The writ was dismissed on 12th January 2021, holding therein that the principle of estoppel would not be applicable to the case in hand, as it was only a communication which was sent to the petitioner with regard to the name having been entered in the minor's register, while the subsequent communication from the superintendent of police was for approaching the authority on the attainment of the age of majority by the ward, an aspect with regard to the delay from the date of death of the father of the appellant till the date of he having attained majority, which is around 11 years, also weighed on the mind of the court in the light of the law as has been laid down by this court in Umesh Kumar Nagpal versus State of Haryana. An intra-court appeal preferred by the appellant resulted in the dismissal of the same on 22nd March 2022, leading to the filing of the present appeal. Learned counsel for the appellant, by making reference to additional documents submitted, that there has been violation of the right of equality relating to consideration for appointment under the ex gratia policy, as it is asserted that in similar factual matters the benefit of appointment on compassionate grounds had been granted. It has been asserted that since the appellant is similarly placed, he should be granted the same benefit. A reference in this regard has been made to Annexures A1 appended along with the appeal. A perusal of the above would indicate that the said benefit of appointment on attaining the age of majority, irrespective of the period having lapsed from the date of death of the parent, had been granted prior to 22nd March 1999, when an outer limit of 3 years for attainment of the age of majority from the date of death of the deceased government employee was introduced by the instructions. Further, in those matters, the age of attainment of majority was also prior to the coming into force of instructions dated 22nd March 1999. That apart, the claim, as has been stated above, cannot be accepted, being not supported with any statutory backing. This is required for making any claim, including a claim for compassionate appointment, which is an exception to the general rule of appointment requiring a proper advertisement and selection process to be followed as per rules, which is an accepted norm. If some wrong benefit has been conferred or some benefit which is contrary to the scheme has been granted, it would not bestow a right upon the others to claim it as a right of equality by reference to Article 14 of the Constitution of India. There are catena of judgments of this court that clearly lay down the principles which govern such claims, some of which are Shanti Sports Club versus Union of India, Chandigarh Administration versus Jagjit Singh, R. Muthu Kumar versus Tangedko, Basavaraj and another versus Special Land Acquisition Officer. The very idea of equality enshrined in Article 14 is a concept clothed in positivity based on law. It can be invoked to enforce a claim having sanctity of law. No direction can therefore be issued mandating the state to perpetuate any illegality or irregularity committed in favor of a person, an individual, or even a group of individuals, which is contrary to the policy or instructions applicable. Similarly, passing of an illegal order wrongfully conferring some right or claim on someone does not entitle a similar claim to be put forth before a court, nor would court be bound to accept such plea. The court will not compel the authority to repeat that illegality over again. Stop.